Hi, welcome to MediatorPodcast.com, a podcast and video series about mediation, negotiation, and collaboration. My name is Melissa Gragg, and I provide online valuation, divorce, and mediation services in St. Louis, Missouri. Today we'll discuss forensic psychology and mediation with Shari Belitz. Shari is an attorney as well as a trial, jury, and litigation consultant in New York. She also owns an educational company that teaches psychology to litigators. Welcome, Shari. How are you?
I'm doing great. Nice to be here, Melissa. Thanks for having me.
Do you see any other ways that these issues show up in mediation or settlement negotiations? And how can we shift an entire case anchor? Like that is kind of, I haven't heard, is it kind of setting the tone for the case-ish?
Well, in the plaintiff's personal injury context, and I'm kind of using that broadly, like that could be anything from a med mal case to a trucking case to anything like that. I'm just not talking really about commercial litigation so much.
Sure.
But anytime an anchor is set, and remember that first anchor can be set, that can be set pre-suit. Maybe there are negotiations going on pre-suit where numbers are being offered, and those numbers, in order to really make your case, and again, this is my bias, I'm used to talking to defense attorneys who are the ones who have to kind of refute those initial anchors because we have primacy going in favor of plaintiffs. They're the ones who are putting out the numbers first. So really the defense bar has got to do their work early, their evaluation early, and come up with their independent data-backed evaluation. That's the situation if we're talking about numbers and demands and things like that, because I will tell you, I've seen a lot of mock trials. I saw one the other day that I was conducting, and it's really scary because the mock jurors, who are very similar to our real jurors, we know they were talking about a demand that was demanded by the plaintiff's attorney in the complaint, and they were really justifying that demand. They were saying, oh, well, he's asking for 20 million for a purpose. There must be a reason. That person must need that much care. He must know something. So that was, I don't even want to say that was an effective way of setting an anchor. That was just slapping a number out there, but you can see what happens in people's minds. So you have to realize, as the defense attorney, or as, I shouldn't be so biased and talk about defense attorneys, but anyone who's trying to defeat an anchor, it is going to take some work. It's not about throwing out another arbitrary number. It is about doing the work, doing the evaluation, taking the data and having the data tell a story, tell a compelling story, whether it's at mediation or whether it's at trial or whether it's kind of somewhere in between it in an informal negotiation.
Yeah. And we've seen in some mock trials that we've done for like training purposes with like a national organization, the NACBA, we have seen, it's very interesting that, sometimes it's the number, and sometimes from an expert perspective, it's the credibility. Like we had one juror that was like, well, that person didn't really look at me. Like they seemed really like rude, like they kind of seemed mean and rude, and they didn't even acknowledge us. And we're all sitting around because we watched the jury deliberate, right, and listen to what they said, and it was fascinating. Like a lot of it didn't have to do with the quantification of the numbers, the methodology, whether it was right or wrong. And we had two experts that were fairly new, right? That's why they were going through it, and it was just fascinating because they were like, you know what? I liked the other guy. I'm going to do the 20 million. And I was like, hold on. Is that the basis of, so I think it does become super important kind of how people relate to people. And that's where the psychology comes in as well. If you can connect with the jury or the judge in some capacity and show your credibility, that goes just as far as making sure that the numbers are right, which changes the game.
That is it's so funny. I just had this conversation with someone a couple of hours ago because I did a post this morning on LinkedIn on direct examination and personalizing your witness, whether your witness is a person or whether your witness is a corporation, about really the mechanics of personalizing them on direct examination, because people, and in this case we mean jurors, will be more receptive to people that they like, people that they trust, and people that they know. So not only will they win in that credibility department, but also studies have shown that they will remember the testimony more once they really have, we like to, in psychology, we say the gestalt, like the whole picture of the case, the whole picture of the witness. Like, let's not look at the witness in a vacuum as someone who has just observed X accident or who was involved in Y situation. Let's look at the person holistically, because that's what's going to build credibility, it's going to build rapport, and it's going to build trust.
Yeah, absolutely. And I think that, I've talked to a lot of other experts around the country, and a lot of times it's unique. And I've had attorneys actually hire me in certain cases because I was a woman. And I think there's a uniqueness in as being an expert and a woman, that it is easier to relate to the jury. It's easier to relate to the judge because we are kind of, trying to engage in some capacity. But I also think that comes with some experience, because when you're first testifying or you're first an attorney, like, you're just trying to do the mechanics, right? Like, get through the case, try to win, da, 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 like, and you're like, okay, okay, do you know what you're talking about? And then when you get a little bit more experience, you're like, okay, the nuances of the psychology become hyper important, right? And you shift because you kind of know the numbers and that stuff, right? You're pretty good at that now. But now you have to shift your focus and say, okay, how do I, from a psychology standpoint, connect with all of the players? Even in some cases, the attorney that is cross-examining me, if I make it really hard for them to like come for me with venom, right? It takes two to tango. And so if I don't tango, you just look like the person that continues to come for me, and I'm not engaged, like, I'm not getting ramped up. I'm not engaging with that. And it becomes a very interesting psychology, to the point that, especially if anybody comes and, the judge says the attorney's gone too far, right? I'm looking for those cues of the judge saying, attorney, you've asked that to me. Like, she's already move on, because then I can see, okay, the judge is listening, right? But also they may be connecting with in the communications.